think it is time for us to get started. So, hello and welcome to So a Neighbor Asked, a monthly series from Mountain State's Legal Foundation, where our attorneys here answer your questions to help you understand the Constitution, the law, and the principles of liberty. I'm your host, Stanton Skrjanek. I'm the communications manager here at Mountain State's Legal Foundation. Before we begin, I want to tell you who we are as Mountain States. MSLF is a nonprofit public interest law firm dedicated to restoring those rights enshrined in the Constitution at zero legal cost to our clients. We are focused on protecting property rights, economic liberty, the right to keep and bear arms, free speech and association, and equality under the law. And that's from our beautiful headquarters here in Colorado, where you see Jim and Will. We litigate crucial cases across the country at every level, including the Supreme Court, and especially those cases that are going to make a difference in our country. And today, I am joined by Mountain State's own General Counsel, Will Trachman, and our senior counsel, Jim Kerwin. Hello, gentlemen. How are you today?
Hi there,
What's your late August day? Is it a beautiful day in Colorado?
It is a nice day, and school has started, although here in Colorado, the schools tend to start on different days. So I've got 4 kids, and we had 3 different start days just by coincidence, but it is what it is.
Rough. That's got to be kind of a disjunctive trying to get their morning routine situated.
That's right. They also started early start times this year. So some bureaucrats decided that my elementary school students will start at 8 and my middle school students will start at 9. So difference in the year.
You love it.
My kids started school too. They actually 2 of our kids go to school together just as a matter of random chance.
No kidding.
Mine just walked to school. It's great. I don't have to deal with them.
That's always
both ways in the snow.
Yeah.
No.
Oh yeah. You love it when they start to get more autonomous. They're like, you guys take yourself to school. Good luck. Have fun. For our viewers here online, after we chat here for about 20 minutes, half hour or so, we'll have a question and answer session to close out the episode. If you're joining us here on Zoom, there's a little Q&A button at the bottom. You can ask your questions. And if you're on Facebook, I'll try to get to your comments as well. I may not get to everyone's comments, but we do appreciate that you ask them anyway. So please do ask. And with that, I'm going to get to the question of today's episode. So a neighbor asked, how is Mountain States preparing itself for going back to school? And by that, I mean, what is it that we're talking about today? We're talking about the best way to pick a school, like parents, how to fix education, or is public education a right, a natural right under your birth? Like, what are we talking about today?
Well, those are all interesting topics. I'd love to talk about them over a beer, but today we'll be talking about free speech in schools, equal protection in schools, and then due process in schools. So that includes mostly student rights, but also we'll be touching on teacher rights as well on a few issues.
Well, I'm very excited for all of that. Now, Jim, I know you're new to the show. You're a first-time host with us here, and I know you're actually relatively new to the foundation as well. You are our guy for free speech and free assembly, and by that association, what can parents and students expect this school year when it comes to those First Amendment protected rights?
Well, thank you, Stanton, for having me here. I'm really excited to be here. I'm glad you asked that question. It's a bit of a good news, bad news, good news situation, I think, for parents and students. To start, the Supreme Court many decades ago, in a very inspirational way, reminded everybody that students do not, quote, leave their constitutional rights to free speech at the schoolyard gate. A very important precedent from the 1960s in a case called Tinker, and that also applies to teachers. So in general, you do have free speech rights when you're in school. You don't lose all those rights just because you passed the doors of your schoolhouse. On the other hand, though, there are some challenges ahead for students and parents, especially students and parents who disagree with what has sort of become the orthodoxy in many school districts around issues of class and race and gender in particular. And so I wanted to spend a little bit of time talking about the students' rights generally and in this particular area, and also parents' rights. So for students, you have free speech rights in school, going all the way back to that Tinker case from the Supreme Court in the 1960s. Over time, there's been kind of a fairly clear set of rules. So you have the right to freely speak in school up to certain limits. Number one, you are not allowed to advocate for the illegal use of drugs. Number two, you're not allowed.
We don't want that being talked about in our schools. We don't want kids just going about, or we just talking about like teachers can't talk about this kind of stuff either, right?
Yes, that would certainly not. Yeah. But these ones are not so controversial, and they're just kind of just to tick them off, just in case you have a student who wants to talk about drug use, you should tell them not to.
Sure.
So you can't advocate illegal drug use. You can't use lewd and patently offensive language, which is, these days not that much. And then there's special rules if you're writing for the student newspaper or something where your speech might be considered by others to actually be the school's speech. Those we can kind of put to one side. The most important piece is that you can speak freely up to the point where you cause a substantial disruption to the educational environment of the school. So as an example, the leading Supreme Court case, there were students who wanted to wear black armbands in the 1960s to school to silently protest the Vietnam War. That was held by the Supreme Court to be protected speech because it would not disrupt what was going on in school. As opposed to that, you can imagine a situation where the students want to march up and down the halls, chanting really loudly. Clearly, if you're in the classroom, you can't hear what your teacher has to say. That would disrupt your educational environment.
Right, absolutely. I used to be a high school teacher. There comes a point where, like, yeah, I want to encourage active voices and opinions in my classroom, but stop talking. I need to get on with my lecture, kind of thing, right? There's a limit to that naturally in a school environment.
I actually have a funny story. The case where the court ruled that you couldn't give lewd and indecent speech First Amendment protections. My buddy was the one who gave that speech and lost the Supreme Court case 7-2. The Fraser in Bethel v. Fraser. And it's always funny that he was giving this high school speech about how someone was firm in their pants and firm all around. And so they were running for high school president in the school, and the Supreme Court, there were actually two justices said, that's protected. You cannot stop the student from being lewd and inappropriate. But as Jim said, that's a little bit less controversial these days, that schools do have that right. Just as you were saying, it's important for teachers to be able to control their classrooms and control the environment a little bit.
Now, Jim, you were talking about something more contemporary this year about the mainstream orthodoxy, so to speak, I think is the way you put it. What do you mean by that, and how does that tie in with the students' speech rights?
That's a great question. So as people are probably aware, many school districts have started to implement policies around pronoun usage and things that are ostensibly imposed to help with the mental well-being of a minority of students who have a disjunction between what they perceive to be their gender and their biological sex. Okay, so this is a very complicated and broad topic, but the speech angle involves school policies that generally require students and staff to use certain means of addressing people so pronouns in particular.
The preferred pronoun idea.
Correct. The preferred pronoun idea. And also, if you've chosen a new name, you started out with a typically boy's name, and you have this distress and disjunction between your view of yourself and your sex, and now you want to be referred to with a different name that's typically associated with girls. That's also something that you may be required by a school to do as another student or a teacher.
Okay.
That sort of stuff. So how does that fit into the free speech paradigm for the student who's being required to use that pronoun that doesn't match with the person's sex or a different name or something like that?
Yeah.
Well, it's a very good question. So one example that I think is useful to think about in this context is a contemporary case that's going through the courts right now, where a student disagreed with those policies and wore a T-shirt to school that had on the T-shirt, it said, there are only two genders. And the school told him he had to take the shirt off. And the question arises, like, in this First Amendment framework, how does that work? Doesn't he have a right to wear that shirt? The shirt isn't lewd or offensive. It doesn't have anything to do with drug use.
And
it's not that anybody would think
this should be a matter of speech that should be protected. That's what Tinker supposedly is saying. So, but is there right. Let me just guess here, because I was being a teacher and working with admin. Is this have something to do with like disruptive via bullying? Like, what's the justification to say it shouldn't be allowed?
Well, in this particular case, the court found there was no disruption of the kind talked about in Tinker. What kind of happened is that there is this emerging view by school districts and some judges that Tinker actually smuggled in another standard that allowed schools to police student speech that was kind of unnoticed by the courts for some decades. And what that is in Tinker, it does say that a school district can limit a student's speech if the speech is disruptive or if it invades the rights of others. All right, now there's, first of all, a question of whether that's really a different standard, because it read in context, I think the Supreme Court was just explaining why it is that if you disrupt the educational environment, that's a bad thing because it disrupts the right of others to get an education. But that aside, some courts have held that this is a distinct ground on which a school can police a student's speech. So the question arises, what does that mean?
Yeah, what is the judges saying that by wearing that T-shirt, you're interfering with another student's rights to what? Right to feel safe, right to what's the ambiguous term I'm waiting for here?
That's the one. So you can imagine some extreme cases. You might try to argue that a student, say the trans-identifying student, has a right not to be irritated by the speech of others. That clearly doesn't seem to be right. Or the right not to be offended. There's lots of case law that says that your right to speak is more important than the listener's right not to be offended. So that's all at one side. At the extreme other side, to be fair to the school districts, you could imagine a situation where somebody is bullying another student like so relentlessly and for so long, when calling them names that they become depressed or suicidal. That's at another extreme. This case is not at either one of those, right? Or maybe it's at the first extreme. There's no allegation that any student was, harassed by this guy just silently wearing a T-shirt with a political statement on it. So this is an emerging area of law that's really important and very active, as to what that, if interfering with the rights of others really is a separate ground on which a school can restrict a student's speech. What does it mean? Do you have a question?
Yeah, so I'm getting the sense that students, that maybe we're being too restrictive on students here, that maybe they should have a bit more openness. What about teachers, specifically teachers and other staff? Like, are they bound to use preferred pronouns because they're employees of the school? Or do they get the same level of protections as students? But help me understand that a little bit more.
So it's actually a little tougher of a road to hoe for teachers and for staff members, say school counselors. There's a separate line of Supreme Court cases that has to do generally with the speech rights of public employees. And the general idea is that just like any other employer, the government, when it employs somebody, has some control over their conduct and their speech so that they can, achieve their legitimate ends or do their business or whatever. So for teachers and school counselors and things like that, it's a little bit harder to make the case under the existing precedent that you have a free speech right not to, for instance, use somebody's preferred pronouns. And that kind of, the analysis is really two steps. The first thing that's asked is whether the government employee is speaking as a citizen or really speaking as part of their job duties.
Yeah.
And, there's certainly questions about this, but like the trend in some of the case law seems to be, especially at the elementary and secondary level, that what you're doing if you are referring to somebody by the pronouns that they prefer is really speaking for the government. So
we're involved in the Vlaming case, which is a Virginia Supreme Court case involving a teacher who did not want to use the preferred pronouns of a student and had a strong religious belief that would not be appropriate for that teacher.
Right.
And in that case, the school district actually said, we're mandated by federal law. We don't have a choice under Title IX, which bars sex discrimination.
They're trying to wash their hands of this, saying, hey, we're sorry, but you got to do this because the feds are telling us. They're trying to wash their hands kind of thing.
Exactly. They were passing the buck to the federal government saying, even if we had a choice whether or not to do this, we don't have a choice because the federal law is that we have to do a preferred pronouns policy. And so we wrote in support of the teacher in that case, arguing that that's a misinterpretation of Title IX and a misinterpretation of federal law. And you're allowed to respect the teacher's student rights. In a Sixth Circuit case called Merriweather, which was a college level case, a professor actually won all the way through and was obtained fees from the university, which had told him he had to use a preferred pronoun policy, and he objected to that. So there are cases, as Jim said, this is a very developing area of law, and there are precedents that don't necessarily harmonize together. But it's an important thing to know that this is developing and going to be upcoming in the next couple of years.
Well, that's great to know. That's actually a major victory. That's huge. You opened up something, and this is my last question, at least from me, on the free speech aspect. Is there a difference in the free speech rights and free association rights of, say, a high school student and a college student at a public university? Is there any difference between the two?
It would be analyzed under the same rubric that, it might be easier to find a disruptive kind of speech at the high school or especially like the middle school. Very unlikely, very easy to find disruption at elementary school, probably.
Right.
More so than at college. You would expect more kind of political activity at a school. Let's say you're marching in protest of a pronoun policy on the quad at a university. That's not going to be found to disrupt speech or disrupt education in the same way that it might at a high school.
I'm glad you mentioned like students marching on a college campus. What about like when students go protesting a speaker at a college campus? They're heckling him, trying to prevent it from talking. Like, is that protected? Or does the university have to like balance? Like, help me understand if they can do that.
Well, that's a great question. So there's really two things going on there. One might be there's a controversial speaker who wants to come onto campus to say something, and the school anticipates, probably reasonably, that will cause the opponents of that speech to come out and heckle him and maybe get violent and maybe have their own. So sometimes governments have tried to silence the first speaker on the grounds that if you say what you have to say, you have a right to say it generally, but it's going to cause all these hecklers to come out and maybe cause a disruption on their part. That is called the heckler's veto. It's a concept in First Amendment law where government should not be able to suppress my speech because somebody who doesn't like my speech is going to cause a ruckus. Does that make sense?
Yeah, the disruption caused by your speech is not caused by you. It's caused by other people who are just.
That's right.
Exactly.
They're getting their feelings hurt. Yeah. Okay.
Right.
Yeah, we wrote a letter to the Stanford Law School just a few months ago where a judge was heckled by students and ultimately shut down. And Stanford is a private school, but they adopt First Amendment standards for their campus, to their credit. And so we wrote them a letter saying, you have failed in upholding your free speech standards by letting this heckler's veto, as Jim was mentioning, occur at this event. The dean of Stanford ended up apologizing and issuing a public letter saying that the students were wrong to do that and mandated free speech training for the entire student body. So that was a good result after our letter was there. But Jim's absolutely right. This heckler's veto is not the fault of the speaker. It's the fault of the people who are engaging in the protests. There's no First Amendment right to shut down someone else's First Amendment rights.
Right. Have your counter protest, have your, whatever, but you can't like just barge in the room and just shut them down. That defeats the whole point of open dialogue, which is what the First Amendment's about, right? Okay.
Right, correct.
So now that we're kind of on this university track, I want to move on to something that I know you're passionate about, Will. What does the world of equal protection look like? So we're transitioning a little bit. What does equal protection look like now for students across the country, both university and even at the high school level and elementary, I suppose?
Yeah, well, so like the free speech area, this is also developing. We've had a couple of positive developments recently. As everyone knows, the Equal Protection Clause protects people from government action. And then there's a corollary statute called Title VI, which is a federal civil rights statute that protects students who go to basically any K-12 school or college, with a few exceptions in the country, from race discrimination. And just in June, we had a very strong Supreme Court decision, a 6-3 decision in the Students for Fair Admission versus Harvard and University of North Carolina cases. And there, the court ruled in very sweeping terms that the use of race in the education context is almost never permissible. And that case was about affirmative action, but the language was so broad in that case that it's been very helpful for our other efforts. So we've already started citing it in several other contexts for the point that there is no viable use of race in the education context, and that if a school does that, they take the risk that they're going to lose in court and end up paying attorney fees for the loss.
So that's incredible. That because I remember going through high school and then even teaching it that the courts have said that universities can use race, but they can't use it as the only thing or the determining thing. It can be incorporated, but just a little bit. And now the court is saying, nope, just stop thinking about it. Just merit only. Is that the basic outcome of that case?
Essentially, I mean, there are some very, very good decisions, including concurrences in that case, about how absurd it is to treat people of all race in the same way, as though an individual based on their skin color contributes to diversity based solely on their skin color, and that the touchstone of anyone's individuality is their race, as opposed to their experiences, their background more broadly. And so those are the types of diversity that a school might be able to seek. Now, what's interesting is the Department of Education, since that decision, has said, well, there's nothing intrinsically wrong with a school hoping that it is racially diverse. So maybe there are ways of recruiting people and having mentorship programs that relate to race, as if you don't make any individual decision. We think we're very skeptical of that sort of statement. And so we'll be pursuing that in a brief before the Supreme Court next month, where we say that even the Department of Education's gloss on the SFFA cases is wrong.
Right, because such ambiguity could open up really, really bad and probably unlawful doors that we want to keep shut.
Yeah, of course, if you're using whatever you're doing as a pretext for getting at race, if you're picking a certain race neutral criteria because you want to ultimately affect the racial balance of your class, that's no better than outright discrimination.
It's just the same thing with a different wrapper, right?
Exactly. Yeah.
So you mentioned so that's broadly equal protection, a constitutional aspect that the government cannot treat citizens differently on the basis of their race. You mentioned something called Title VI. What? Expand on that a little more. What is Title VI?
Title VI is a federal statute that says if you accept federal dollars, you agree to not discriminate based on race in your school. So whether or not you're public or private, if you have students that get Pell Grants or other federal scholarships, you're subject to Title VI. So that's why Harvard was the defendant in the affirmative action case, despite the fact that Harvard is a private school and not bound by the Equal Protection Clause.
Does Title VI? So I know we were talking about race, race-based admissions, but I know that admissions isn't the only thing that schools have to deal with. What about disciplinary action? A high school certainly has to deal with it. Does Title VI affect how schools discipline students? What is that?
Absolutely.
Factor?
So a school wouldn't be allowed to treat students differently based on race for the purpose of suspending someone or expelling someone. You're not allowed to say, well, because your skin color is this, we're going to treat you more harshly or less harshly than we would someone else who is in the same position. There's an issue, though, which is that some people point to statistical disparities. So rather than pointing to individual instances where, say, two students had a fight and one of the students was punished differently than the other student, what they're saying is, if you look at the racial demographics of a school district, say it's 20% white, 40% African-American, but your numbers overall are that 100% of students who are suspended are African-American, or maybe 80% as a more likely example, then that itself is prima facie evidence of racism. And you might get investigated by the federal government because your numbers are off. The Obama administration affirmatively said, we will go ahead and investigate you. We might force you to answer our questions and give us documents. And that had a chilling effect, unfortunately, on a lot of schools that gerrymandered their numbers and actually violated Title VI by less severely disciplining students who are non-white. The Trump administration withdrew that guidance, to its credit, And the Biden administration recently decided to reinstate a lot of that guidance to say that if you have numbers that look off, you are going to be subject to federal investigation and potentially the loss of your funds, maybe the closure of your school. And so we've published an op-ed saying that this is itself a violation of Title VI, where you're encouraging schools to engage in racial decisions and punish students who are not white less severely in order to match the numbers that you think you ought to have.
And that makes sense, right? I mean,
yeah.
So you're briefly, we've covered a lot of ground already, a lot of legal theory, a lot of legal background. Where is Mountain States in the thick of it? We've mentioned a couple cases, mentioned a couple action. Where are we in the thick of both of these issues? First Amendment free speech and in equal protection.
Well, I'll just mention one case that we haven't talked about yet, which is the Berkeley graduation case. There, as you referred to, it's not an admissions case, but Berkeley hosts a graduation ceremony for African-American students called the Black graduation. And the ceremony, if you look on the website, is cultivated exclusively for African-American students. And the attendees are African-American who go on stage and accept an award. It's a graduation, and Title VI and the Equal Protection Clause both say, look, if you want to have a program or activity at your school, you have to have it open to all, regardless of race. And so we've alleged with the Office for Civil Rights that that graduation ceremony is itself a violation of these principles. And so far, we've gotten good news. The Civil Rights Office, even under President Biden, has opened the investigation and has told us that they're looking into the Berkeley situation. But more broadly, it's just the idea that schools take account of race at their own risk at this point after SFFA. So whether that's diversity or some other reason, we really do think there's quite a bit of legal vulnerability there.
So I actually was talking to one of my neighbors about something around this. What about these historically Black colleges? I know that's a big thing and frequently in the South. How does that play into this conversation? Are these, why should they exist? Are they allowed to exist? Help me understand their place here.
I'm glad that we have a literal reference to So a Neighbor Asked, that your neighbor actually asked this question. So HBCUs, or historically Black colleges and universities, are subject to Title VI, just like every university and every school. And so while they may draw African Americans who apply there, technically anyone is allowed to apply, and the admission standards are just the same. Now, a lot of times Congress will fund schools based on the fact that they are HBCUs. So some HBCUs have had financial trouble lately, and Congress has targeted funds at those. But technically, those are arguably race-neutral funding mechanisms because they're trying to assist with schools who are in financial trouble. Although I could see an argument being made that if Congress is targeting certain funds based on your status as an HBCU, that might be race conscious. But HBCU itself, in terms of admissions and programming, is also subject to Title VI and the Equal Protection Clause.
So they might look and they might even have the name historically Black, but really they also abide by those same neutral.
Exactly.
Okay.
Yeah.
Okay.
Yeah. Have your neighbor call me if that's yeah.
I'll be able to do that. What about free speech? Any other free speech work that Mountain States is involved in?
So in addition to the Stanford letter that Will talked about a minute ago, and protecting the rights of speakers there from the heckler's veto, we're involved in several appeals, including, I mentioned the case about the student wearing the T-shirt. There are only two genders, and there are other appeals that we're also weighing in on. That's an area of focus for us at the moment is about these gender-related policies and their effect on the free speech rights of students and teachers.
Yeah, the case law recently is good. One case that we were involved in 2 years ago was called Kennedy v. Bramerton, and that involved a coach who wanted to pray at the 50-yard line after football games were over. And the court ruled in his favor 6-3 that he had the free speech right at school to engage in prayer, and that wasn't a violation of the Establishment Clause or the separation of church and state. And so the court is tuned in on these issues, particularly on compelled speech, which is the other side of the coin. There's a lot of rules about when a government entity can stop you from speaking. But the case law on compelled speech is even stronger. It's very rare that the government can compel you to actually engage in speech. And so those cases are definitely going to be a target of ours, whether it's forcing you to use pronouns in a specific way or other forms of affirmation of what the school is insisting that you believe.
We're on the active lookout to start taking those a bit more aggressively, which is great news.
Yeah.
I want to move on to question and answer. We've got a couple questions here, and it looks like they're both more or less oriented for Jim. So, Jim, you are a popular man today. Jack from Montana. He's asked, you've spoken a great deal about speech codes and pronoun policies at public schools and universities. What about if your child attends a private school that has its own agenda that you disagree with, that you don't want your child to imbibe? How do you answer Jack?
So the First Amendment applies only to governmental restrictions on speech in almost all circumstances. It would be a public school is a government, so its action is directly limited by the First Amendment free speech rights of the students and teachers and anybody else. A private organization, it generally is not directly limited by the First Amendment. There can be some exceptions if the government more or less coerces a private entity to violate the free speech rights of a third person, in which case there might be enough to say that there's state action and there's been a violation of the First Amendment by the private entity acting as an agent of the government. So that's one thing. Another thing that somebody might look into in a case like that, if they don't have the government forcing the school to act the way that it's acting, is just to see if the school itself has its own free speech policies, which many schools might, and to see whether there might be some sort of enforceable contractual right that the parent has that the school actually, it might have these high-flown ideals that it says, we have a policy to allow speech and that we won't interfere with it except for in the same sorts of circumstances that a government might interfere under the First Amendment. And if they're not actually carrying that out, a parent might consider whether they have some sort of legal rights under those policies.
Yeah. So at the college level, what's interesting is that the Trump administration issued regulations saying, if you're a private school, you don't have a First Amendment that binds you. But if you make a bunch of commitments in your student handbook or your brochures, when you're trying to draw people in to apply to your school, you have to live up to those commitments. So if you have a marketplace of ideas reference in your brochures or your handbook, and then all of a sudden you squash the marketplace of ideas, you actually are violating your contract. The Biden administration right now is attempting to withdraw those rules, but they still exist for the time being. We cited them in our letter to Stanford because when the school induces people to attend there based on those promises, they have to live up to them.
Awesome. I got a question here from Saul. I've always been troubled by the current emphasis on differential impact of policies in education, policing, testing, employment, and so on. The usual answer these days is to lower or eliminate standards until everyone meets those standards. The meaning of the bell curve is inexorable and remains whether we acknowledge it or not. How should the law handle these differences? That's a good question. That's a very well done question. Thank you, Saul.
Yeah, absolutely. So the brief that we'll be filing next month is in a case called the Thomas Jefferson High School case. We're supporting through an amicus effort, the Supreme Court taking on a case. This involves a Virginia high school that rejiggered its admissions process in order to disadvantage Asian students. So they have a facially neutral policy saying we'll take the top 3% of every middle school into our high school. But what they were really doing, and they admit this, was trying to reduce the number of Asian American students that go to that school. We've also seen some colleges get rid of the SAT in order to change the racial makeup of their school. We've also seen some high schools get rid of high-level math in the interests of equity or inclusion because they don't want such a differentiation. So I think that's what our commenter is asking about. And those things are vulnerable, just as the Thomas Jefferson case is about something that's purportedly facially neutral. Getting rid of the SAT is one of the requirements for your school. If you're doing that in order to change the racial makeup of your class, or if you're changing what courses you offer at the K-12 level because you want different racial demographics to be just as successful as other racial demographics, those are definitely vulnerable to legal challenge at this point.
Yeah, and by changing them, you're impacting everyone else as well, who would otherwise benefit from different standards or different tests.
Yeah, so there was a part of the SFA decision that Chief Justice Roberts, who's very good on this issue, made, which is that the nature of a racial preference inherently disadvantages other racial demographics. You can never just have an isolated racial preference that only benefits as opposed to also detracts. And that's part of the lesson that Mountain States has had throughout its history, all the way to when we litigated the Adirondack case in the 90s, that there is no such thing as a benign racial preference, that they're all equally bad.
Exactly. All right, I have one more question here, and then we'll wrap it up. Jim, this is back to you here. I'm gonna there's quite long, so I'm gonna summarize this as best I can. They're talking about how their child in college, to public college, they were taking a test. No, they're writing an essay. Here he is. Sorry, I'm reading this for the first time. They're writing this essay, which is supposed to be argumentative and persuasive, and the professor marks them down because it advocated a position contrary to the professor's ideas, specifically about the Second Amendment. Okay, so this is something I know that we have some work here. If I'm getting this right, students trying to do a persuasive, argumentative essay, professor grades it, marks it down because it's on an opinion about the Second Amendment that they don't like. Can the professor do that? Within the professor's purview as an educator, or is this something that we start getting really messy about First Amendment between students and teachers?
Well, it's a very good question. College professors have a little bit more leeway, again, in terms of what goes on in their classroom. There is actually a case right now working its way through the courts from the Rhode Island College, where a graduate student has sued professors and the administration in his field because some of his claims were very similar to this. Like, he was told, we have a particular point of view it was a school of social work in terms of how to achieve social outcomes that we want. And all of those ideas are progressive ideas. And the student said, I actually think, in my own view, that reducing taxes, for example, or regulation at the end of the day is a better way to achieve the same social ends, but he was told that he could not express those views and he would be downgraded for them. He won his case at the Rhode Island Supreme Court in terms of whether there had been a violation of his First Amendment rights.
Wow.
Though it's a complicated procedural history. He had already graduated, so there's a question as to whether that law was clearly established at the time so that he could recover damages. And that's actually the issue that's currently up. So I would say it depends on the facts of the case. It's difficult, you can't comment on anything particular, but a school may be vulnerable in an extreme situation where they are retaliating against a student purely because they hold certain political views.
Absolutely. It's going to be fact-bound, because if the professor says, hey, I want you to write an essay pro-Second Amendment this week and anti-Second Amendment next week, and then you refuse and you write 2 pro-Second Amendment arguments, then you might have some sort of neutral reason for saying, oh, well, I can't grade you well because you didn't follow directions.
Right. That's a pedagogical example of like trying to teach thinking skills as compared to enforcing some doctrine or another.
Right. Okay. So if you can literally pin it to the speech and the retaliation is occurring because of the speech, then that is absolutely vulnerable.
Well, that's fantastic. I mean, that's great news. I like to hear that. That's good news for free speech. Okay, we're gonna start wrapping up here. Gentlemen, I want to give you one last opportunity to speak your piece, to mention a word of hope or word of affirmation. What do we have to look forward to this school year for Mountain States in terms of free speech and equality?
So like a lot of people, I send my kids to public school, and public schools are having a lot of challenges these days in terms of preserving our constitutional rights. And so it isn't as though we ought to hope that public schools just get it right and understand what their legal duties are. We need to know. We need to figure out what our constitutional and legal rights are and make sure that schools know them, abide by them, and in appropriate cases, take legal action when they don't. So public schools right now really are in a place where we'll see in the next couple of years where they're trending. But the trend certainly is, as Jim was mentioning, against liberty, against free speech. And so the only way to push back on that is by knowing your rights and being willing to defend them.
That's right. I would just echo that and say I started with the good news, bad news, good news. I didn't get to the second part. I forgot that even though there are these trends that are going in the wrong direction, the good news is that Mountain States Legal Foundation and other organizations are taking aggressive legal action on behalf of students and parents, and it's being effective.
That's wonderful news. We like being effective. We like it that Mountain States is leading the charge. So everyone, I hope you gained quite a bit, that you understood that you can answer your neighbor's question like I'm going to be able to just here in a moment. Thank you all for joining us on this episode of So a Neighbor Asked. Thank you, Jim. Thank you, Will, for being wonderful hosts. Within a week, actually, hopefully in a few days, we should have this webinar uploaded to our YouTube channel for future viewing. In the meantime, you can be sure to keep up to date with all of our important work and all those cases that they were talking about on our website, mslegal.org. And you can find us on Twitter. Well, I guess it's called X now, at MSLF, Instagram at Mountain States Legal, or of course, you can find us here on Facebook. So thank you again, everyone. We look forward to seeing you next month. Have a good day. Bye-bye.
Thank you.
Thank you.